Hi, this is Annalisa Care, and in this video, I wanted to take you step by step on how to use the guide to applying and to doing your own application for naturalization. So I'm going to share my screen and I will explain each section so that you can understand if there are any confusions on the guide. So let's get started. Okay, so here I am on the first page. You don't need the first page. And this is a guide to doing your own naturalization application. It is actually one of the easiest applications that you can do. And so sometimes it is worth doing it yourself as long as you know exactly what the requirements are, because if you don't, then you're basically wasting the immigration fees because they don't do refunds, unfortunately. In fact, I had one client who called me today and he got refused for his naturalization application because he thought that he knew the requirements, and he, as a layperson who don't know the inside and out of the policies, the rules, then sometimes that can happen. But majority of people can actually do their own naturalization application without any problem. So let's get started. So the first section that you will find on the guide is, it says, make sure you hold indefinite leave to remain. So one of the requirements before you can think of applying is, think first, can I apply to become British? And one of the first requirements that you must consider is, do I have indefinite leave to remain? Now, there are categories of applicants, and the reason for this is because there are different rules to when you can actually apply for naturalization. So on the table here, we can see married to or in civil partnership with a British citizen. So if you're married to a British citizen or in civil partnership with a British citizen, so that's one category. If you're an EU citizen, and for the rest of the other applicants. So if you are not an EU citizen or in civil partnership or married to a British citizen, then you belong to the other applicants. And then the question, when can you apply? So if you are married to or in civil partnership with a British citizen, you can apply straight after obtaining the indefinite leave to remain. So essentially, if you were granted today indefinitely to remain, then the next day you can apply for British citizenship, absolutely no problem. And let me explain why there are differences. And the reason for this is because they changed the immigration rules. So it used to be that if you're married to a British citizen, it would only take you 3 years to apply to be eligible for indefinite leave to remain. Now they changed that to 5 years, so that now you have the spouse visa, and they issued it 2.5 years at a time. And provided that you are on the 5-year route, you can, after your 5 years of holding this visa, you can apply to become British citizen. Now, so obviously, with immigration rules changed, the British Nationality Act did not change. So it's still the same. So if you're married to a British citizen, it says you can apply for British citizenship after 3 years. So, but you can't apply after 3 years because you wouldn't be holding the indefinite leave to remain. And that's why after 5 years, you can apply straight away. Okay, for EU citizens. Now, this should be straightforward. If I was recording this after 2021, year 2021, when all the rules are the same. But at the moment, there are those, if you are an EU citizen and holding a permanent resident status, if you've still not applied for your settled status, then it says here, after holding 12 months of permanent resident status or settled status. Okay, so you have to have the record when you were granted the settled status. After 12 months, then you can apply to become a British citizen. And for the rest of the applicants, it's the same rules for EU citizens. Still, you have to hold the indefinite leave to remain status for 12 months, and it's only after 12 months you can apply for citizenship. Okay, so I hope that's very clear. I don't think there's any confusion there at all. Okay, so the second section are the requirements, and one of them is the life in the UK test. So life in the UK test, this is a knowledge of the UK culture, the UK rules. So in the box here, you can practice your test and you can book your test. But what do we mean by life in the UK test? Well, life in the UK test, it has no expiration date. So if you have this test certificate, there's no expiration date. So for example, if you had it 5 years ago and you want to apply, let's say next year, you can still use that life in the UK test certificate. And if you are over 65 years old, you are exempt from providing this certificate. You don't have to sit the test. And also, if you have a long-term physical or mental condition, then you may be exempt from this requirement, as long as you have a medical evidence, so medical certificate to show that you actually are in a long-term physical or mental condition. The other requirement is the English language. Now, of course, it's obvious that if you are going to be a British citizen in the UK, you must be able to speak English. You must have a bit of knowledge of English. And so you have to have English requirements. And these are the two requirements that are really mandatory for applying for British citizenship. If one of those are missing, if you don't have life in the UK test or English language test, then it will be refused straight away. So what do we mean by English language test? Well, English language test, there are exemptions. Okay, so first we do the exemptions. If you are over 65 years old, then you are exempt. And if you are a national of one of the following countries, and these are the English speaking countries, you are also going to be exempt, and you will need proof that you are a national from that country, and it may be your birth certificate from the country or your passport. And it says here, Antigua, Australia, Bahamas, Barbados, Belize, Canada. So all these countries, sorry, I've included United Kingdom, but that shouldn't be there. But it's one of those English-speaking countries. And if you sit your test, so the test would be B1, okay, B1, and speaking and listening in English, B1 at Home Office approved test and test center. So you can book your test here, and this is valid for 2 years. So please take note, it's valid only for 2 years. So if you had one of those English requirements when you did your indefinite leave to remain, then that will be valid as long as you've sat that test to less than 2 years. You can use that certificate. The other is if you have a UK degree. So if you have a UK degree, then you don't have to sit this B1 test. And also, if you have a degree in English-speaking country, you can also do that, but that must have NARIC certificate. And if you have a certificate in English, again, that has to be supported with a NARIC certificate. And for those of you who don't know what NARIC is, it's actually an organization that is one of those agencies that confirms your qualifications abroad. So if you have qualification abroad, then it searches and matches it with the UK qualification, and that's what it is. So you need, if you have a degree in English-speaking country, so not in, let's say, in the UK, let's say some other countries, then you need a NARIC to confirm what the equivalent of that qualification is. Okay, so because some degrees are not the same as the UK. So if you may have, let's say, a degree in the Philippines, that's English-speaking country, but it's not recognized as one of the English-speaking countries, that will get you exempted from the English language requirement. But your degree, because it was taught in English, may be enough, may be sufficient for this requirement, but it has to have the NARIC certificate. And the NARIC, it costs money, okay? So maybe that you have to wait a long time to have the NARIC certificate. And so it may be worth, you have to balance it whether you want to sit the B1 test, which is very easy, or you have to have your English degree, get a UK equivalent through NARIC and get the certificate, what the equivalent of that degree is in the UK. Okay, so let's move on. The third is the residence. Now, So we have, again, we have two categories. If you're married or in civil partnership to a British citizen, then you must not be absent for 270 days in the 3-year period. And the reason why there's a 3-year period, it's because this is from the British Nationality Act. Okay, so it's different from the immigration rules. So that's why they have not changed it. So you only have to prove that you've been in the UK for 3 years. Okay, so 270 days, and then you must not be absent for 90 days in the last 12 months before the application. So, for example, so this 12 months requirement. So, for example, you want to apply today, and so you go back 12 months. So were you absent from the UK for a total of 90 days? If you were absent for 90 days, then that goes beyond this requirement, because there are two stages to this requirement. One is the total amount of absence in the 3-year period, and the total amount of the absence in the last 12 months. So this is quite important. So two stages, one in the total in 3 years, and the second is the total in the last 12 months. And so you have to check your passports, where you've been and how many days you've been absent. For all other applicants, so it says must not be absent from the UK for a total of 450 days in the 5-year period. So you have to count, especially EU nationals, you have to count how many days you've been out of the country. It may be impossible to check it, right? But check your boarding passes, your bookings with the airlines. You must have emails confirming where you've been, and what holidays you booked and how many days you've been absent. So for the 5-year period, you must not be absent for 450 days. And in the last 12 months, you must not be absent for a total of 90 days. Okay, so it says here, if you do not meet the residence requirements, you must collect evidence of the reasons you stayed abroad for lengthy periods. The Home Office has discretion to consider your application even if you go over the absences required. So, for example, there may be reasons why for example, you've been out of the country for, instead of 90 days, 110 days, let's say. Okay, so that's going over 20 days, the required absence. So if you can explain why there was, why you were absent for the extra 20 days, let's say, for example, you were ill and you were in the hospital, or you were stationed, in connection with your employment, you were sent to another country and worked there for 20 days, or you had business meetings, then you need to provide evidence, and don't expect the Home Office to just pick it up and and then grant you the naturalization. That you have to include a covering letter, evidence as well, why you do not meet the residency requirements. This is the reason why you need a cover letter. Okay. The fourth one is the good character requirement. This is a recent introduction of the naturalization application. So if you see the graphics here, I don't know if you can see, but there's, so excluding the gray one, you can see the gray one. Okay, so the rest, 1, 2, 3, 4, 5, 6 of these categories are considered what the Home Office should consider when they decide whether or not you have a good character. Okay, so let's take, for example, let's do the financial soundness first. Okay, so financial soundness, if it means, are you responsible with your finances? Do you have any debt? Have you become bankrupt? Have you not paid your council tax? Are you a director of a company that has closed down, or like gone bankrupt as well? So this is what it means. And they consider if you have any records like county court judgments, debts that you haven't paid, they consider this. But to give you a bit of an example, just because you have county court judgments against you that you need to pay, let's say rent arrears or whatever debts that you have, does not mean that you will automatically get refused. Okay, it doesn't mean that. It just means that if you have county court judgment, the Home Office will usually ask, what evidence have you got to show that you have started making payment towards the court order? Okay, and an example of this is I had a client who came to me. She had a county court judgment against her and her ex-husband because she was separated at the time. So it's to do with the rent arrears that they haven't paid, and the landlord took them to court and obtained a court order against them, and it was for a debt of over something like over £6,000. And because she did not pay towards the debt, the Home Office did not automatically refuse the application. They actually wrote to us and asked us, what evidence does she have to show that she's been making payment or making arrangement to pay the debt. And in fact, I advised her, because at that time it was a county court judgment, and she really did not want to pay it because she believed that it wasn't her debt, it was her ex-husband. Her ex-husband did not pay the rent. He was responsible for it. She was saying, well, I was, not going to pay it. So she didn't. And so even though I explained to her, I said, if we could just show that you contacted the landlord and entered an agreement with them to say, I'll be making an installment, and then we can show that agreement to the Home Office, then you may have a chance of getting the naturalization. But because she refused, she wanted to withdraw the application, and so that didn't go further. So what point I was trying to make is to not get disheartened, or not automatically think that just because you have county court judgment against you would mean that you will automatically get refused on your application. It really depends on the circumstances, and if you can show that you have paid it already, or making payment towards it, and there's agreement in place, then you may be able to convince the Home Office that although despite of that court order, you have a good character. Okay, so the second one is other bad behavior, such as criminal association or undesirable conduct. So this can be, I suppose, being a member of a gang, I suppose. Okay, so and then if we go on to clockwise, so I won't. I'll mention this good behavior. If you have charity work or served in armed forces, then that can be considered as good behavior. The other one is this deception and dishonesty. Now, what do we mean by deception and dishonesty? So dealing with other departments of government, including benefits, in application for British citizenship, in previous immigration applications. So if you've been found dishonest, or you have a record of deception or deceiving government departments, that would have a record on the system. And so if you don't disclose it, they will still find it, and they may think that you don't have good character. In one of the example is, I had a client who encountered the police, and he actually forgot to mention in his application that he had encountered them, and he got a fine for I think indecent exposure in the toilet. Okay, and he applied for student visa. I don't know whether it was deliberate not to mention this encounter with the police, but when he sent his application, he complied with all the requirements except for the fact that he didn't mention this encounter with the police, and so they refused him. And I think he had a record of deceiving the Home Office, and so if he later on obtained indefinitely to remain, and then he has record of deception, then he needs to disclose that. Okay, and it may be considered that he doesn't have good character. Okay, so he needs to kind of balance it and see what other things he can do to mitigate that record. So he may have to show that he's been doing some charity work, something like that. Okay, so next is the criminal conviction. Now, criminal convictions, just because you have criminal convictions doesn't mean that you can't apply to become British, but it means that you have to wait so many years if you have criminal convictions. So for example, you will be refused if So this is the worst case. You will be refused if you have had convictions and you've been sentenced to prison for 4 years or more. Okay, so if you've just recently been out and you want to apply for British citizenship, but you've had 4 years, you've been in prison for 4 years or more, then there is no chance of you getting the British citizenship, unfortunately. If you have been in prison for 12 months and 4 years in prison, so if you went to prison for 12 months and 4 years, then you have to wait 15 years after you've come out from prison. So if you were, let's say, you came out of prison 10 years ago, okay, and you were serving 12 months sentence, then you need to wait another 5 years before you can consider applying for naturalization and before you can consider that you have a good character. Otherwise, if you apply, you just lose your money. Okay, so if you have been in prison for up to 12 months, then you have to wait 10 years. Okay, so let's say you were discharged from serving 8 months in prison for 5 years ago. Then it means you need to wait another 5 years to kind of erase that record and be able to show that you have good character. And then if you have any other sentences like suspended sentence, fine, then it's best to, it says here, it's best to wait, not best, but you have to wait 3 years in order for you to be considered to have the good character. Okay, so this is quite important. If you have criminal records, then you need to really, time it correctly. Otherwise, you'd be wasting your money. In fact, one example of this is I had a client who applied for British naturalization, and when he applied, he did not have conviction, so he did not have any criminal record. But before the Home Office looked at his application and made a decision, he was in trouble. He had an argument with his wife, and then he got arrested. There was some domestic violence incident, and he got arrested, and he was charged with criminal damage, I think, of property, or assault, aggravated assault, something like that. So when they looked at it, even though he made the application, let's say in January, and then October, he had the criminal record. He was in trouble with the police, and then they looked at it again in December, the application. They refused it on the basis that he had criminal record, and they were saying that he didn't, you didn't tell us that you had criminal record, and so he was refused. And so because he had criminal record, he had to wait, because although he didn't go to prison, so up to 12 months, it says non-custodial sentence. So I think he just got fined. Then he had to wait for 3 years before he can apply for naturalization. Okay, so I hope that's quite clear. Now, the other one is war crimes, terrorism, and other activity contrary to the public good. I don't want to go through that because it's, this is like serious offense. So if you have been charged with these offenses, then it's a complete rejection of your application. Now, finally, let me deal with the overstaying, illegal entry, and breaches of immigration law. Let's see. So if you've entered the UK illegally, okay, if you've been involved with sham marriage, if you have hired illegal workers, then if you were deprived of British citizenship, if you've evaded immigration control, evaded means they sent out you've overstayed, and then you were supposed to report, but you didn't report. This is what evading immigration control is. If you've cheated, if you've been found cheating on knowledge of life in life test or English language test, or have been prosecuted for making false statement in an application, or assisted with evasion of immigration control, or non-compliance with workers registration scheme. This is to do with EU citizens. and then if you're complicit in deception by a referee. So these are all, immigration breaches of immigration law. So if you've been found, if you have one of these, then it's most likely it will be refused. But it's quite common. The common ones are entered UK illegally, or you've overstayed. Okay, so this is overstaying as well. I don't know why it's not included here, but that should be included here. If you've overstayed. So for example, if you've overstayed, let's say 3 years ago, and you have obtained your indefinite leave to remain. So the last date of your overstay, the first date of getting the visa or entering the UK legally would mean that that's the first day of your 10 years, okay? So even though you have been in the UK before, let's say 2011, and then you overstayed in 2013, and then you came to the UK 2014, then you can't apply now because it's only 2020. They check 10 years, going back 10 years. So you have to wait 10 years. Unfortunately, you're one of these like criminal convictions in the last 10 years. It's worse than that. They really take this seriously. And I think it's to give some sort of example to other people who overstay. And although before they didn't really pick up on this, but they've now kind of punished, it's like some kind of punishment for overstayers when they apply for British citizenship. And so it takes them longer to become a British citizen if they've overstayed. Okay, so I hope that's quite clear, okay? It's really not difficult. It's really not confusing as long as you know what they're looking for, good character requirement. And just because you have a little bit of bad dealings before, it doesn't mean that you will get refused straight away. It's only the red ones, okay? The red ones of pink, dark pink, how do you call it? Deception, dishonesty, criminal convictions, overstaying, immigration breaches of immigration law, war crimes, and so on. These are the only ones that will, if you have one of these and you have not been upfront, not waited the right time, then you will get refused. Usually rejected, it says here. Okay. Okay. So in addition, paying tax, no criminal record, or clear immigration history will most likely be considered as good character. Please note that even if you have some past financial problems or have encountered the police, you do not necessarily get rejected. The Home Office, in our experience, may require additional information about these issues, but best to disclose anything in your application, even if you do not think they are relevant. I'm saying this, it's because if you forget to tell something, then that really will work against you. So mention anything, even though you haven't got the details. Like for example, I had the client that I mentioned earlier about having a court judgment in relation to the court arrears. The landlord took them to court and she had to pay like 6,000 with her ex-husband. She also had other like kind of criminal, not really criminal, but it's under that category. So she was arrested for shoplifting, and but she didn't know what was going on because she didn't know English at the time. And she went to the police station. Apparently she was interviewed, but really she did not have a clue. So anything that she told me, we just wrote everything down to the Home Office. We mentioned it and we said we haven't got any more details, we haven't got any documents. So so you are upfront. They really appreciate honesty, even though it's not relevant. Okay, so it's better to be upfront, even though it's not relevant. Okay, now, so I'm giving you an actual example of a refusal letter. The one I mentioned to you about, the one who applied for British citizenship and who got refused because he was convicted and did not disclose it. Well, he couldn't have disclosed it to them because they already have the application. He already submitted it, and it's only months after that he had domestic violence incidents. And so this is the actual refusal letter. And it says you were convicted on blah, blah, blah. As your conviction is not one that we would normally disregard, nor can we find grounds to disregard the exceptionally outside our published policy, we cannot be satisfied that the good character requirement is met. So its application is refused. Okay. So that's the actual letter to show you what they would normally look. But it says here, it is open to you to reapply for citizenship at any time, but your failure to disclose a conviction to us. Oh, so see, I didn't notice this. So I was referring to you about the 3 years, but it says here it is open to you to reapply for citizenship at any time, but your failure to disclose a conviction to us will be taken into consideration on any fresh application made within 10 years of the date of this letter. So because he did not inform them of his conviction, and he couldn't have done because he already submitted his application, he didn't know how could he communicate to the Home Office. It's so difficult to communicate to the Home Office, right? What they do is they hide their details. What was he supposed to do? Was he supposed to call them? There isn't anything on the application form that says, if your circumstances change, please inform us, and this is the email to inform us. Something like that. I can't. I think I'm dealing with applications day in and day out. I haven't come across an email address to inform the Home Office of a change of circumstances. Anyway, you see how severe that is. It's so unfortunate for him. Okay, so now we look at the referees. The referees, you need 2 suitable referees. So there's a lot of confusion about the suitable referees. Who do I have to ask for referees? So 2 ones. Firstly, the first referee can be of any nationality. So they don't have to be British, but they have to have professional standing. So one has to be professional. And we mean by professional, they accountant, civil servant, minister of religion, lawyer, nurse, doctor, dentist, vet. So all those who have professional, titles, I suppose, and they must not be related to the applicant. The second referee must be British. Okay, so take note, must be British and over 25 years old. And they don't have to have professional standing. So it can be, anyone who is British, as long as they're British and to over 25 years old and not related to the applicant. Okay, and these are the following details that the referees must provide when you apply. Okay, so full details. Okay, it's over there. So, and then where to start your application. Okay, so if you have all of those, if you tick all the boxes and you thought, okay, wow, I can apply. You see how it's straightforward that is? Then you click here. Okay, so start your online application, click here, and it'll take you to the online application form. And we make it so easy for you as well. We have also taken the excerpt, actually the actual immigration application online questions that you have. You see, we completed this in August. So this is what it is. So what the questions are, what they ask you. Okay, so all of these are in these pages here. And I won't go through that because you can read it yourself. So once you have submitted your application, okay, so you have to download the referee's declaration. Okay, so your referee 1 and your referee 2 will need to sign, and you need to have that document, that declaration, and then your own declaration. So the second one is then that will take you to, once you paid your fees, they will take you to UK VCAS, and you can book your appointment for your biometrics. And this is the login details. Okay, so you set up your email and your password, and then you can also choose your service point, where you're going to go. So the closest, so you can enter the closest center. You enter your postcode here, and it will show you what the closest center and where is the available appointment. Okay, so in London, you've got London, Croydon, Victoria, and so on. Okay, so it's got it will come up with all the list of visa centers. And then you choose your appointment. And the appointment at the moment, there's no free appointment. You have to pay £110 for your appointment. And you select it and then pay for the appointments. Then on top of that, you can also choose services. So if you don't have a scanner, so everything is online now. So if you don't have a scanner, then you can pay £50 to get the visa center to scan all your documents for you. So you have to, tick here and say you want document scanning, or if you want SMS service, text alert, then you can also buy that for $199. And then if you want the document checking, which I doubt you need this, because if you have everything everything else that I've mentioned above, there's a checklist, there's also a checklist down below. You won't need it, but in case you want to double check, but just to make sure they are not immigration people, and if they get it wrong, then you just be wasting $44.99, and they're not going to take responsibility. You can't say, oh, by the way, yeah, I used UKVCAS service, they checked my documents, and how come I've been refused? So this, for me as a lawyer, this will be a waste of money. If you are going to make sure that your documents are okay, then have it checked by a lawyer, not the UKVC center, because they're not qualified, and also they are not going to take responsibility if they make a mistake. If you need interpretation of your documents, then they have that, and maybe you need this if you need to interpret your documents. And then you need to pay and submit. You will get a confirmation of your appointment and the services that you bought. Okay, so just in case you want to upload your own documents, then this is how you do it. Okay, so you just click upload, and then it's really straightforward. I've done it myself, and it's really straightforward, as long as you've got all your documents saved already on the computer. So it's got everything here. Okay, so I won't go through that. We just included this in the guides for completeness sake. Okay, so you know what to expect, you know what you have to do, and then what you have to do to cancel your appointment, for example, and then what the documents will be required. So this is what your document. So not many people will know this. So if you have downloaded this, then you are one of the lucky ones. Okay, so documents required. You need valid passport, your valid passport. They won't take it from you, but you need to scan all the pages. Okay, don't just scan the first page, because the reason why you need to scan all the pages is because it will show whether or not you have been out of the country. It will have the passport stamps, right? So that can be proof, because they ask for proof of residence. Okay, whether you've been resident in the UK, and the only way to do that is to get your passport to show whether you've actually said, on the rest, like the absences, whether it's correct. And then all other old passports. If you have old passports, also scan them. All pages, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. So when I say all pages, not just the stamped ones. Okay, so there's a difference between show the stamped pages or all pages. All pages means all pages. Page 1, page 2, page 3, page 4, page 5, up to the end. Scan it. And again, the reason why you need to scan it is so you can show that you have been honest about your residency. Okay, so that if you said you've not been absent 90 days the last 12 months, then it's correct. If you said you've not been absent the last 5 years for 450 days, then it's correct. The only way to show that, it's not by by documents, it's by your old passports. Okay, so if you have biometric card, then submit that. You need that. Life in the UK test, which is the most important. The English language test is also the most important. And then if you're employed, recent P60 and payslips and letter from employer will be sufficient. If you're self-employed, the most recent tax return. If you're married, your marriage certificate. If you're married to British passport or UK naturalization certificate of the spouse. Okay, so those are the requirements. There may be some more requirements that's not mentioned here, but the checklist, when you submit, there will be a checklist that says what you need to show. So here we've kindly added all the additional links that you can see. So we've added the Home Office guidance as well. If you want to read it yourself, it's very long, and then you've got the link as well to the Form AN guidance, so naturalization guidance. This is the Home Office. So if you want to double check everything that I've said, whether it's correct or not, then then you feel free to read all of these resources. Okay. Now, so that's it for do-it-yourself naturalization. It's the most straightforward naturalization applications in the world, And if you have benefited from this guide, then please consider liking our or following our Do It Yourself Immigration UK, or subscribe to our YouTube channel. Or if you have any questions whatsoever that you want to clarify, either the good character requirement, the residency requirement, then you can book an appointment here. That will be phone appointment for 30 minutes. And the reason why 30 minutes, it's because it's only going to take you 30 minutes to ask question. Unless your case is really complicated, then if it's really complicated, then it's not worth of you wasting money on the naturalization or wasting money on starting the application. Consult with a lawyer first, okay? So it only takes 30 minutes to answer any queries about naturalization. So it's only going to cost you also £50. Now, that's the best £50 you can ever invest in your immigration naturalization application. So that's it. Okay, so thank you very much for going through this guide with me, and have a great day. See you soon and catch up with you. Thank you. Bye.